I want to bring an important update with regards to the notice to appear in the deportation proceedings for those people who are illegally in the United States, especially when they lose their job, when the company withdraws the H-1B. Some of them did receive the notice to appear. As things are flying around, we just want to give some updates to the people. Emily, of course, we noticed this more than a month ago, and we are the first ones to report on it. And then we did collected some data with regards to the notice to appear. Obviously, initially when it came, we thought probably it's a fake, but then we realized that it's not. And then we did publish in the YouTube more than a month ago. And now I see that, a lot of things are spreading around the rumors. Can you update me what is going on the notice to appear from the time when we initially reported to right now?
Yeah, so we are still seeing them. So about a month ago, we received our first one, not from a client of ours. As you mentioned, we kind of thought it was fake because looking through the statements that were being made, the allegations of how this person was removable, they were completely wrong. The individual was in H-1B status, lost the job, filed a change of status within the 60-day grace period. During that time, the previous employer also notified USCIS of the employment termination, which leads to a withdrawal of the H-1B, which leads to a revocation. That's what's supposed to happen. The company is supposed to notify USCIS in the event of employment termination. And this notice to appear says, well, because you stayed beyond the date that your revocation happened, you are removable because you had your visa revoked, which all of that is completely wrong. It's not a visa that's been revoked, it's the petition. Yes, a visa revocation could make someone removable. A petition revocation, when the person is in the 60-day grace period and has filed a change of status or a transfer, they're not removable. They're lawfully in this country. They're still in H-1B status during the 60-day grace period. So it's completely wrong. We got one, and then a few days go by and we start seeing 2, 3, 4. It is still happening. We are not seeing it spread as much as what one might think based on how much is now being talked about on different YouTube channels and social media. I kind of liken this to what was happening a few months ago with F1 student visas and the SEVIS terminations, that we got one person who contacted us saying their SEVIS record was unexpectedly terminated, and then it turned into 5, and then 10, and then 20, and 100, and then within 2 weeks it was like 6,000. That is not what's happening here. It's nowhere near to that level from what we can tell. So we're trying to figure out what USCIS is doing and reaching out. I've been reaching out to multiple people within USCIS as I can, as well as urging people to contact their senator, their congressman, send letters themselves, emails themselves. The good news is one of the parts of USCIS that I reached out to actually responded back and asked for additional information. And over the last few weeks, we've been going back and forth, sharing information and trying to provide them the data that they need. And they came back to me earlier this week and said they have raised this issue to their subject matter experts, and they'll let me know from that standpoint. So to me, that's a good sign. That they are looking into this. We also know that the American Immigration Lawyers Association has now started asking for examples of this happening so that they can maybe reach out to USCIS. But we have a direct line at this point with them, and they do seem to be looking into the issue because these are completely wrong situations. Now, the good thing is most people that are facing this issue are being able to successfully resolve them. I don't know, Stephen, if you want to kind of give us an update on what we're seeing. Like, is the change of status being approved? Are they getting these removal proceedings terminated? Where are we at with that?
Yeah, just real quick though, before we go there, I do think it's funny. You mentioned the American Immigration Lawyers Association was now collecting it. I think I saw that email yesterday. But just to kind of put a bow on this, Emily has been pounding the pavement since day one, reaching out to USCIS, multiple communications with them. So big shout out to you, Emily, to trying to affect positive change here from your office. But we are seeing, to your point, Emily, some positive trend lines. So far, all these individuals that have contacted us had something, right, filed during that 60-day grace period. I noticed all of them had something before the NTA. It just didn't, only a couple of them have popped up in the NTA allegations. Not all of them, they mention it, but they did file. And we are seeing the extensions of status get approved with the I-94, the change of status get approved. We are not seeing adverse actions on the administrative side of USCIS, which is great. It's kind of ironic in a legal sense in that you have one wing of USCIS saying, we're going to issue a notice to appear because we think you're unlawfully present, you've overstayed. And then, the adjudication, which is USCIS's role is benefits adjudication, is saying, you're good. You maintained your status. You're lawfully present, so we can grant this. And so it's a little bit ironic. And we've had at least one case where the NTA has been dismissed. I've heard rumors of others from other attorneys out there as well. And so we are seeing some positive trend lines, which is why we wanted to provide an update because, Rahul, you've got a very good ear to the ground with people, and you're being sent YouTube links where people are saying you need to leave right away and just, throw in your backpack and just grab what you can and leave. And I don't know if that's the advice I would be giving. What's going on? What are you seeing, Rahul?
Yeah, that's what Stephen and Emily and Stephen is that I've been noticing a lot of it, that people are asking simple question: what do we need to prevent the NTA? First thing is, I don't know what can be done because we have seen people who have upped the H-1B transferred to a different company applied. We have seen people who are in adjustment of status who's lost a job and they got an NTA. We have seen people who have applied for H-4 in the proper typing that got the NTA. We have seen people who have applied within 60 days for the B2 that got an NTA. So nothing I can say that will prevent people to not get an NTA though. Now, I have had also people where the person has left the country working for the FANG company and still got the NTA. There is nothing. But however, as Emily has pointed out that we haven't seen this in a large scale though, as what we have seen in the civil system termination of the student visa. Initially, it was one, and it just become like a hailstorm at one point of time, where everybody who was involved with any kind of police activity just got their service suspended. But if not all the people whose H-1B is getting withdrawn after they left the country are getting this notice to appear. It seems that it's very small percentage at this point of time. Now, as you pointed out, Emily, that there are corrective actions, seems to be that USCIS may take it because it's the USCIS that has issued this notice to appear, unlike the Immigration Customs Enforcement. And as Stephen has rightfully pointed out, though, even though the notice to appear has been issued, we have seen H-1B transfers getting approved. We have seen H-4s getting approved. We have also noticed that the case has been filed to dismiss it in the notice to appear, and we got some of the cases, not our office, but we have the people that we work in, got their notice to appear, got dismissed at this point of time. So the million-dollar question that Stephen asked right now is, if I were to lose the job right now, and if I have an opportunity to move on to either H-4, B2, or B2, or probably move to a different job within 60 days, with the fear of NTA, will I leave the country right now? The answer is simply straightforward: no, I will not leave the country. Now, am I telling everybody to do the same thing? Sometimes I can't tell because, if I were the client, having the knowledge that I have, if I lose the job and within 60 days, either I'm taking the action of moving to B2 or H-4 or moving to another job in H-1B, I am not going to leave the job. I may, if it comes, I will face a notice to appear though, because It is not the same level what I have seen in the student visa where CVs got terminated. And for the people, I want to note down that those people who left the country in the service system got terminated are the people who really got punished. Because those people who stayed in the country, as Stephen did successfully argued in the courts and got them reversed for not only his clients, but everybody there with his efforts that he did. So at this point of time, what Emily is doing, then efforts, I am pretty confident that it will be reversed. But if it's not, it's still only insignificant of the people who are getting this notice to appear. So if I were the client, if I lose the job, if my company is willing is withdrawing the H-1B, I'm still going to stay in the country. I'm not going to leave the country.
Well, and that's why, Rahul, I think it's important to stay up to date with information, but with good information. If I had $1 for the Instagram and Twitter rumors and YouTube rumors that are being misapplied, but that's why we are doing these sessions, is to keep people up to date. I think it's important for people to make that informed decision. Look, if your choice is to leave, I don't think you have to, but that's we make decisions every day on things. Things can go right or wrong with every decision, but I think we are not seeing anything where people are having the negative repercussions from staying and fighting this out or pushing on their benefits. I mean, and to your point, Rahul, about the SEVIS litigation, folks, the people that did leave are getting stuck and getting refused at the consulates and aren't getting back. The people that fought are in a good space right now. And so, I think everybody needs to be informed of what we're seeing on this.
Yeah, I think
Now,
a lot of things dealing with the law is all about managing risk. And in immigration, you really have to weigh the risk of staying in the US after a termination during the 60-day grace period and filing a change of status or a transfer or relying on your adjustment of status versus the risk of a potential NTA. And the risk of these NTAs at this moment still seems to be quite low. It's not spreading like other issues we've had in the past. Of course, that could still happen, but we're hoping that with the actions we've been taking up to this point, we're going to nip this in the bud. But knowing these risks, you just have to weigh the pros and cons and make a decision for yourself what you're comfortable with. Some people might be very conservative and not want to deal with anything at all and prefer to exit the US. But as both Raul and Stephen rightly pointed out, even people who left the US got these NTAs, and some of them have received a final order of removal in absentia because they didn't show up to the hearing because they didn't know about it or were outside the US when they got it. So that doesn't solve anything. And there, as Rahul mentioned, there's not really a way to avoid this. I mean, they do seem to be mostly triggered by a withdrawal by the company after a termination, but the company is required to do this. Could you ask the company to maybe wait to withdraw or not withdraw? You could ask, but they are supposed to be withdrawing. They're doing the right thing. Everyone's doing the right thing here. We just have to get the right people's attention to this, which I think we've been making progress on that. I do still think that people who are facing this issue should be reaching out to their congressman or senator for their assistance to try to get more people aware of this issue. But the risk is still quite small in my mind.
Emily, a couple of things I want to point out people that if anybody is getting an NTA, what should they do? Should they just see that the things will get resolved, or should they hire a local lawyer to represent to dismiss the case? What are the steps if they get an NTA? And also, if somebody doesn't get an NTA, is there a way, because you're telling people that there are some people who didn't receive an NTA, but they're directly report the deportation order. How do people know if they don't get a mail? Because these people, they're sending this NTA in the normal mail, not even FedEx, not even a proper service though. How do we people know that it's been served?
Yeah. So to the first point, like, what do you do if you do get one? Number one, you have to take it seriously and you have to take action on it. And there's kind of two sides to the situation. You have what's going on with your case with USCIS. Keep doing what you were doing. If you were planning on filing a B2, if you were planning on filing an H4, if you were planning on filing a transfer, if you were going to rely on your 485, go ahead and still do that, because we are still seeing those getting approved even after the NTA is issued. The other side of it is, now what do we do about the NTA itself? And so for that, you need to immediately hire a local attorney that handles removal proceedings in your area, wherever that court is, because they're going to be familiar with what that local court's rules and procedures are, because they're all a little bit different. And they're going to be best to guide you on how can we get this terminated. Do we need to file a motion to terminate? Do we need to get the government attorney involved? What are the steps to do that? But we are seeing people that have been able to successfully get them terminated. As far as what do you do if you didn't receive one? So there is the EOIR website where you can enter your A number and it will pop up and show you if there's a court date in your future. So I would recommend monitoring that. I would also recommend monitoring the online case status of the receipt number for the H-1B or whatever case it was where you left the company, to see if that company has sent a notice of withdrawal, to see if USCIS has received it. It'll say something like received correspondence, and then it might say confirmation of withdrawal sent or something like that. So just monitor that for updates. I think it's harder for people that don't have an A number yet, because you typically won't get that until you have an approved I-140. So if you're before that, I'm not really sure what you can do other than making sure that your address is always updated so that you do receive whatever mail is being sent by USCIS.
Stephen, instead of going to the deportation proceedings where the judges may not be independent, they are kind of employees of the immigration service, though, can we directly go to the federal court where the judges are independent instead of going to the deportation proceedings and get this thing resolved?
No, not with an NTA. There are jurisdictional bars where we cannot challenge removal proceedings in federal court. It's very clear they have jurisdiction. Now, there is, after, if there's an order of removal and you appeal to the BIA, you can do a petition for review with the circuit court, and that is an Article 3 court, a federal court, not a administrative law court. But no, you cannot just challenge that and get it. Now, if you are detained, which we have not seen, we have not seen, there are ways to challenge the detention with habeas through federal court, but in terms of the NTA, no.
I just want to report to the people, for those people who receive the NTAs, under the circumstances where the H-1B was being withdrawn, none of them were being detained. Even if they have gone to the deportation proceedings also, where they appeared for the notice to appear, none of them were being detained. So I just want to report so that people are not panicked to go to the immigration courts, because you see the YouTube right now where people are saying that you go to immigration court, they're going to detain. Not this particular kind of clients we have not seen. If they have something else, I don't know. But if this is the only thing that they have, where the notice to appear has been because the H-1B has been withdrawn after you left the job, we have not seen. Anything else, Emily and Stephen?
Nope, I think that's pretty much covers it.
We do provide a link at the bottom where Emily has provided a blog. If anybody has received an NTA, even if you're a friend, even if you did not receive an NTA, you should report this to the immigration, your congressman. I have provided a link for you at the bottom of the website. And if you want to speak with Emily, Stephen, me, or anybody else in our office, our schedule is available online. You can block a time that is suitable to you. Thank you for tuning in. Please subscribe to our news channel.